Hello everybody, and welcome to my video blog, which is part of my website, uslegalwriting.com. If you've been to my site, you know that I offer legal research and writing services for lawyers. Lawyers only, not members of the general public. Now, I've tried to make that clear on the site, but still, I get quite a few inquiries from folks who are handling their own cases in court, and they want me to help them. Usually in the end, it boils down to the same thing. What they need is for me to prepare some court pleadings for them, which they could then sign and file. I have to say that sometimes the issues are pretty interesting and I'm tempted, especially when it seems to me that I'm dealing with a really nice person who genuinely needs some help. So here's the question. Is it okay for a contract lawyer to ghostwrite a pleading for a layperson? The answer is a flat no. This is definitely not okay unless the layperson in question happens to be in the contract freelance lawyer's home jurisdiction. So, when I'm asked to do this, my answer is always the same. Sorry, I just can't. Now, some might say this is a little harsh, especially in light of ABA Formal Opinion 07446. Which says that a lawyer may draft a pleading for a non-lawyer litigant and allow that pleading to be submitted in court without advising the court of the lawyer's involvement. Well, that sounds like I'd be on pretty safe ground accepting some of these requests that come in through my site. But would I? I don't think so. Opinion 07446 is about the unbundling of legal services. It supports the idea that a client and her lawyer should be free to decide which services the lawyer will and won't provide. It's basically saying that if the client and his lawyer agree that the lawyer will draft something for the client to sign and submit in court, then that's okay. But here's the thing. The opinion assumes that the layperson and the lawyer have an attorney-client relationship. It assumes that if the lawyer did sign and submit the pleading for the client, that would be fine too. Why? Because the lawyer is admitted to practice in that state, before that court. To me, this makes all the difference. I don't think Opinion 07446 can be stretched to invite ghostwriting by lawyers in jurisdictions where they are not admitted to practice. Whether or not ghostwriting is okay for lawyers in their home states, it's fine in Alabama, for example, but not in Kentucky, Connecticut, Colorado, New York, and Delaware. I think it's completely out of bounds for a contract attorney who is not admitted where the pro se action is filed. In my opinion, if I were to ghostwrite a pleading in Arizona, for example, where I'm not admitted, I'd be practicing law there. The key issue is not whether I sign the pleading, obviously not okay, but whether I provide professional legal advice directly to the non-lawyer. This is exactly what I'd be doing if I were to draft the pleading as requested. Now, ghostwriting a pleading for a layperson is, to my mind, very different from doing research and writing for a lawyer in another jurisdiction. Freelance lawyers do that all the time. Of course, and that's fine. Sometimes this seems like a fine point to the folks who contact me and ask for my help. So I always take the time to explain why I have to decline. And most of the time, they understand. But whether they do or not, I always have to give the same answer.